The following is the official document that led to the April 16, 1902 release of Amer Ben Ali from prison. At the time he was in Dannemora prison. There are two issues, in my opinion, that are not addressed in the decision of Governor Benjamin Odell. One being that the key to the room in the East River Hotel was not authenticated. Despite the best efforts of Detective Robert McNaught, who had been involved in the investigation into Carrie Brown's murder, McNaught was unable to provide conclusive evidence that the key turned in by George Damon was in use back at the time of the murder in the hotel. An affidavit from the proprietor at the time rejected the suggestion the key Damon turned in matched keys on the floor where the murder occurred. The other issue is the description of the man, the so-called Danish farmhand who worked for Damon and allegedly left the key to room 31 of the East River Hotel at Damon's residence before taking off for parts unknown. It doesn't match the description given by the only person to have seen Brown and her last client on the night of April 23, 1891. With that in mind, this is the April 16, 1902 decision rendered by Governor Odell. George Frank. Sentenced July 10, 1891. County, New York. Crime, murder, second degree. Term, life. Sing Sing prison. Commuted to 10 years, 9 months, and 10 days, actual time. This application is based solely upon the ground that the prisoner is innocent. It is insisted that the evidence upon which he was convicted was exceedingly weak and unconvincing so as scarcely to be legally sufficient, and that the doubt arising upon the evidence alone is such as to render the case a proper one for executive intervention, and further, that evidence recently discovered and now adduced is of such a character as practically demonstrate his innocence. The murder of which he was convicted was peculiarly atrocious and revolting. The victim was a dissolute woman about 60 years of age. About midnight, April 23, 1891, she and a companion, not the prisoner, retired together to a room to which they had been assigned on the upper floor of the East River Hotel, a low lodging house on Catherine Slip, New York City. As they failed to appear on the following morning, the clerk opened the door with his pass key and discovered the woman lying dead on the bed. She had first been strangled and her body had then been horribly mutilated. Her companion was gone. Just when he left, the evidence was not disclosed. It was entirely silent on that subject. The key of the room was also missing. The prisoner had occupied a room directly across the hall and had left the house at about 5 o'clock in the morning. The evidence to connect him with the crime was necessarily circumstantial. It was testified by experts that a chemical analysis of the scrapings of his fingernails showed substances similar to those found in the stomach of the murdered woman. Witnesses testified that, during the day following the murder, they found traces of blood leading from the room occupied by the deceased to that of the prisoner. As reported by the district attorney, the proof on this subject was that 3 drops of blood were found in the hallway that led to the April 16, a spot of blood on the lower panel of the door of the Amer Ben Ali from just under the lock. At the time, inside of the same door, some spots. There are some on the paper in the hallway which the police that are not addressed in the decision of Governor Benjamin Odell. Affidavits are now produced, one made by persons of credit, the room in the East River Hotel was not authenticated in the investigation of crime, despite the best that they visited the scene of the murder shortly after its discovery, who had been involved in the investigation and made a careful into Carrie Brown's murder. McNaught and that they unable to provide conclusive evidence at all events. Turned in by George Damon was in use back at the time of the murder in the hotel. One of these is by Mr. Jacob from the proprietor. At the time, he says he arrived at the hotel about noon and examined the place carefully, where, viewing the room where the murder was committed, the other issue is the description of the man, and that he noticed no blood spots on the floor between the prisoner's room and allegedly left the key to room 31 none on the door of the hotel at Damon's residence, inside or outside, before taking off, and none in the prisoner's room. And it doesn't match to the best of his knowledge by the only person to have seen there were no Brown blood spots on the floor of the hall on the night of April 23, 1891. With that in mind, This is
It is
April
insisted
16,
by the prisoner's counsel that these affidavits
by
are
Governor
strongly
Odell,
corroborated by the fact
George
that
Frank,
no blood stains were
sentenced
found
July
by
10,
any person on the knob or panels
County,
of the door
New
of the
York.
murdered woman's
Crime,
room.
murder,
Upon
second
this point,
degree,
he says,
term,
it was
life,
inferred against
Sing
the
Sing
prisoner that
prison,
in the brief transit
commuted
across
to
the
10
hall
years,
to his own
9
room,
months,
blood
and
dripped
10
on the
days,
floor,
actual time.
and that he daubed the walls
This
in his
application
groping,
is based
and
solely
soiled the
upon the
panels of
ground
his door
that the
on
prisoner
both
is
sides and
innocent.
opening it, and
It
again
is insisted that
enclosing
the
it,
evidence
while
upon
in
which he was
unlocking
convicted was
and locking
exceedingly
the door
weak
of the
and
room in which the
unconvincing, so as
butchery had just
scarcely
been
to be legally
perpetrated.
sufficient,
No sign
and
of
that the
blood
doubt
was
arising
left
upon
behind.
the evidence alone
Near
is
the
such
scene a
as to
knife
render
was
the
found,
case a proper
probably
one
the
for
one
executive
used by the
intervention.
murderer.
And
And evidence
further,
was given
that
tending
evidence
to show that
recently discovered
3 or
and now
4 months
adduced is of
before,
such a character
the prisoner was in
as
possession of a
practically
knife of the
demonstrate his
same kind,
innocence.
except its blade
The
was
murder
not
of which he
broken
was
or
convicted was
filed down
peculiarly
to a
atrocious
point
and
as was that of
revolting.
the knife found.
The victim was a
There was
dissolute
also
woman
some
about
proof when
60
arrested.
years of age.
Blood stains were
About
found
midnight,
on different parts
April
of the
23,
prisoner's clothing.
1891,
Some
she
further
and a
facts
companion,
were proved,
not the prisoner,
but they had little,
retired
if
together
any,
to a
bearing
room to
upon the
which they had
question
been
of his
assigned
guilt.
on the upper floor
It
of
must
the
be
East River
conceded that the
Hotel,
evidence,
a low
even when
lodging
wholly
house on
undisputed,
Catherine Slip,
was weak and
New York City.
inconclusive, and it
As
is
they
contended
failed
that
to
the
appear
jury
on the
must have
following
regarded
morning,
it,
the clerk
that
opened
there
the
is
door
no other way
with
of
his
accounting
pass
for the
key
verdict,
and
that
discovered
there
the
was
woman
no
lying
ground
dead
whatever
on the
for
bed.
designating the
She
crime
had
as
first
murder in
been
the
strangled,
second
and her
degree,
body had then
and
been
that it could have
horribly
been found
mutilated.
only on account
Her
of serious
companion was
doubt
gone.
existing in the minds
Just
of the
when he
jurors
left, the
as
evidence
to
was
the
not
prisoner's
disclosed.
guilt.
It was
But
entirely
it is
silent
insisted that
on
his
that
innocence
subject.
is now fully
The key of the
established by
room
the
was
new
also
evidence.
missing.
This
The prisoner had
consists of
occupied a
affidavits
room
going to
directly
show
across
that
the hall
on the morning after
and had
the
left
murder,
the house at
the
about
key of the
5
room
o'clock
in which
in the
the
morning.
crime was committed was
The
in
evidence
the
to
possession
connect
of a man
him with
who
the
had been
crime
for
was
some weeks
necessarily
in the employ of a
circumstantial.
resident of Cranford,
It was
New
testified
Jersey.
by experts
He had
that
been
a chemical
absent during the
analysis
night
of the scrapings of
returned
his
to Cranford
fingernails
in the
showed
morning.
substances similar
A
to
few
those
days
found in the
afterward, he
stomach
left
of
without
the murdered
notice to his
woman.
employer.
Witnesses
and,
testified
upon cleaning
that
up his room,
during the day following
the
the
key was
murder,
found,
they
together
found
with a
traces
shirt
of blood
covered
leading
with
from
blood
the room
stains.
occupied by the
A brass
deceased to
tag
that of
was
the
attached
prisoner.
to the key bearing
As
the number of
reported
the
by
room,
the district
which had
attorney,
been
the proof on
occupied
this
by the
subject was that
deceased
3
and her
drops
companion.
of blood were found in
It
the
was
hallway.
afterwards
A
compared with
spot
other
of blood
keys
on the
at the
lower
hotel,
panel of the door
and
of the
found to be
prisoner's
like
room,
them in every
just
respect,
under the lock.
and
On
evidently
the inside
part
of the same
same
door
set.
some spots,
The man
and some
referred
on
to
the
was a
paper in
stranger
the
at
hallway which
Cranford,
the police
having been
officers
brought
had cut
there
out.
by his employer.
Affidavits
and has never
are now
been heard of
produced,
since he
made by
disappeared.
persons of credit,
These affidavits
some of whom
are all
had
of them by
experience
persons
in the
of repute,
investigation of
the
crime,
principal one
that they
being made
visited
by
the
a
scene of the
gentleman
murder
who
shortly
has been
after its
engaged in
discovery
business in
and
the
made a
city of
careful
New York for
examination
upwards
of the
of 30
premises,
years,
and that
who
they
is vouched
discovered
for
no
by
blood
Governor
stains.
Voorhees as a man
At all
of excellent
events,
character.
None having a tendency
No
to
motive to
connect the
misrepresent
prisoner
is
with the
apparent.
homicide, and unless the
One of these
affidavits
is by
are
Mr.
pure
Jacob A.
fabrication,
Reese.
there can be no
He
doubt
says he arrived
that
at
the
the hotel
was
about
wrongfully
noon and
convicted.
examined the place carefully.
Whoever committed the murder
viewing
must
the room
have had
where
the
the
key,
murder was committed,
and the other
if the key
rooms
was
on
found
the
as
same
alleged,
floor,
the
and
prisoner
that he
could
noticed
not
no blood
possibly have
spots
had it.
on the floor between
Attention
the prisoner's
has been
room
called to some
and
further
that of the
facts
deceased,
tending to establish
none
the
on the door of the
prisoner's
prisoner's room,
but it is not
inside or
necessary
outside,
to refer to them
and none in the
particularly.
prisoner's room.
I
And
appreciate
that,
fully
to
the
the
serious
best of his
objections
knowledge and belief,
that exist to the
there were
retrying
no
of cases
blood
upon
spots on the floor of
applications
the
for
hall or
executive
in
clemency
and around the room
as a
occupied
general
by
rule,
and
the
one to
prisoner.
which there can be but
It is
few
accepted
exceptions.
by the prisoner's
The judgment
counsel
of the
that
trial
these
court ought
affidavits
to be
are
regarded
strongly
as
corroborated
conclusive.
by the fact that
But
no
the
blood
present
stains were
application is
found by
altogether
any person
exceptional.
on the knob or
The evidence
panels
upon
of the
which
door
the
of the
prisoner
murdered
was
woman's
convicted
room
was extremely meager.
Upon this point, he
Some
says,
of it was,
it was
to say the
inferred
least,
against the prisoner
of an
that in the
exceedingly
brief transit
untrustworthy
across the hall
character.
to his
He
own
was
room,
tried under very
blood dripped on the
disadvantageous
floor,
circumstances,
and that he daubed the walls
and it is
in his
impossible
groping,
to resist the
and soiled the
conclusion
panels of
that
his
had the
door
new
on both
evidence been
sides and
produced
opening
upon
it,
the trial,
and
an
again
acquittal must have
enclosing it,
resulted.
while in unlocking
This evidence
and
was
locking
not
the
then
door of the
accessible,
room in which the
and its
butchery had just
non-production
been
cannot
perpetrated
likely attributed
no
to lack
sign
of
of blood
diligence.
was left behind.
To refuse relief
Near the
under
scene, a
such
knife was
circumstances
found,
would be plainly a
probably
denial
the one
of justice.
used by the murderer.
And after a
And
very
evidence
careful
was given
consideration
tending to
of
show
all the
that
facts,
3
I have
or
reached the
4 months
conclusion
before,
that it is
the
clearly
prisoner
my
was in
duty
possession of
to
a
order
knife
the
of the
prisoner's
same kind,
release.
except its blade was not broken or filed down to a point as was that of the knife found. There was also some proof when arrested. Blood stains were found on different parts of the prisoner's clothing. Some further facts were proved, but they had little, if any, bearing upon the question of his guilt. It must be conceded that the evidence, even when wholly undisputed, was weak and inconclusive, and it is contended that the jury must have regarded it, that there is no other way of accounting for the verdict, that there was no ground whatever for designating the crime as murder in the second degree, and that it could have been found only on account of serious doubt existing in the minds of the jurors as to the prisoner's guilt. But it is insisted that his innocence is now fully established by the new evidence. This consists of affidavits going to show that, on the morning after the murder, the key of the room in which the crime was committed was in the possession of a man who had been for some weeks in the employ of a resident of Cranford, New Jersey. He had been absent during the night and returned to Cranford in the morning. A few days afterward he left without notice to his employer, and, upon cleaning up his room, the key was found, together with a shirt covered with blood stains. A brass tag was attached to the key bearing the number of the room, which had been occupied by the deceased and her companion. It was afterwards compared with other keys at the hotel and found to be like them in every respect, and evidently part of the same set. The man referred to was a stranger at Cranford, having been brought there by his employer, and has never been heard of since he disappeared. These affidavits are all of them by persons of repute, the principal one being made by a gentleman who has been engaged in business in the city of New York for upwards of 30 years, and who is vouched for by Governor Voorhees as a man of excellent character. No motive to misrepresent is apparent, and unless the affidavits are a pure fabrication, there can be no doubt that the prisoner was wrongfully convicted. Whoever committed the murder must have had the key, and, if the key was found as alleged, the prisoner could not possibly have had it. Attention has been called to some further facts tending to establish the prisoner's innocence, but it is not necessary to refer to them particularly. I appreciate fully the serious objections that exist to the retrying of cases upon applications for executive clemency. As a general rule, and one to which there can be but few exceptions, the judgment of the trial court ought to be regarded as conclusive. But the present application is altogether exceptional. The evidence upon which the prisoner was convicted was extremely meager. Some of it was, to say the least, of an exceedingly untrustworthy character. He was tried under very disadvantageous circumstances, and it is impossible to resist the conclusion that had the new evidence been produced upon the trial an acquittal must have resulted. This evidence was not then accessible, and its non-production cannot justly attribute it to lack of diligence. To refuse relief under such circumstances would be plainly a denial of justice, and after a very careful consideration of all the facts, I have reached the conclusion that it is clearly my duty to order the prisoner's release.